Hello, everyone. Welcome to week 6, and it's chapter 6, so that we can, this is the first time I'm actually doing a WIMBA with voice, so that you'll be able to hear some of the interesting things that are going on as we go along. This is professional negligence and medical malpractice. There are two definitions here. For malpractice, it's professional misconduct or some unreasonable lack of skill that causes an injury or damage or loss to the patient. Negligence is unintentional. It's an act that does occur when the person either does or does not do an action that any reasonable person with training would or would not have done in a similar situation. What is the tort of negligence? Well, we have a couple of things here that lead up to us learning the 4 Ds of negligence. It's malfeasance or misfeasance. Malfeasance performs a wrong or illegal act. Misfeasance is improperly performing what would have been lawful. And then there is nonfeasance, which is kind of like a non-entity. It's failure to perform any necessary action. So it could be one of the 3 in order to be classified as a tort of negligence. Now, you need to understand that an attorney taking on a case would try to answer these questions. Was there a duty that was made by a responsible physician to the patient, some sort of a relationship by the patient calling and making an appointment, the doctor showing up for that appointment, seeing the patient, and treating them? That establishes duty. Dereliction of duty would be neglect. That kind of speaks for itself. Direct or proximate cause would be a continuation or a sequence of events unbroken by any intervening cause that produces injury, which ordinarily would not have occurred if it hadn't been done. And damages, this is kind of the biggest one of all. Injuries that are caused by the defendant. If there is no damage, then it's kind of like no harm, no foul. You may have certainly met the duty, dereliction, and direct approximate cause, but if you walk away fine, there's no damage. Now, for damages, there are ways that an attorney will try to solve this case, or settle this case. One is compensatory, which makes up for pain or loss of emotional pain and suffering, loss of income, things such as that. There's punitive or exemplary damages, which is if a person has been harmed maliciously or willfully, there is a monetary award awarded to that person. There's a nominal damage. Not much has been done to the patient, or there hasn't been any major upset in their life, so they would get maybe a slight or token payment awarded by the court to show that it's kind of like a slap on the wrist. There needs to be a preponderance of evidence before any case is taken by an attorney. They usually do it on a contingency basis. So once they have a discovery team that goes out and tries to establish whether or not there's enough information to go forward, then they will do so. Now we come up to some of the words that you've been learning in class, like res ipsa loquitur, which literally means the thing speaks for itself, or let the master answer. There have to be 3 conditions for this to take place. The injury couldn't have occurred without somebody doing something negligent. The defendant had direct control over the cause of the injury, and the patient did not and could not contribute to the injury. Moving forward to fraud, we have a couple of slides on this. Firstly, there is a good definition here, the deliberate misrepresentation or concealment of facts for unlawful gain. And it is one of the fastest growing crimes in the world, actually, because it can be fraud of all types. Medical assistants have been in several fraud cases in the medical office, but so far none have been charged. It has gone directly to the provider. But when it comes to Medicare or Medicaid programs, those federal programs, the Inspector General does protect those programs from any kind of fraudulent activity at all. So there are some defense tactics that can be applied during a malpractice suit. One is the affirmative defense, which is flat-out denial or assumption of any risk, contributory negligence, or borrowed servant, which we'll get to in a minute, statute of limitations, or res judicata. The defendant is allowed to present evidence that the patient's condition was the result of factors other than negligence. There's a denial defense, which would be a second one. The plaintiff must prove that the defendant did a wrongful or negligent act. It's the most common defense of all. And then there's a jury, generally, that has to determine if the defendant, in fact, caused that injury. And usually expert witnesses are brought in, maybe even on both sides, contradicting each other, and it's up to the jury or the judge to decide which one weighs more and is more important. The assumption of risk prevents the plaintiff from recovering any damage if that plaintiff voluntarily accepts the risk associated with the activity. The best example I can think of this is somebody going on an amusement park ride, for example, where it says, you're not allowed on this unless you're 3'8", and understand if you're pregnant or you have a back injury, we don't say that this is going to be a totally safe ride. If someone gets on this ride having read that anyway, they have accepted the risk and they've assumed the risk, so to speak. It would be great if all of these places would have a signature required. Not all do, so it's a matter of proving it or not. And as I said, the assumption of risk, if it has the patient or the person that is taking part in the activity, whether it's surgery or it's traction for your back or any kind of physical therapy, a shot, anything that's done that has a risk to it, if there's a signature involved before the process is attempted, then it is assumed that the person has knowledge of the risk, understands it, and consents to treatment. Now, contributory negligence has absolutely no damage payment to the plaintiff at all. It says that the part of the plaintiff, any conduct on the part of the plaintiff, will contribute to that injury. There's comparative negligence, kind of similar to contributory, saying that the plaintiff's own negligence caused the injury, and it allows the plaintiff to recover damages based on the amount of the defendant's fault. In the driving world, it's often said that ignorance is no excuse. If you don't know something but you do it anyway while you're driving, you're at fault. It's kind of the same thing with this, comparative negligence. Borrowed servant is a special application of respondeat superior. It basically says that if you are working in a medical office and Dr. So-and-so down the hall, medical assistant didn't show up, you had some time and your boss let you go work there. If something happened while you were under the supervision of that other doctor, you would not be held liable, nor would your actual employer be held liable for any negligence caused by the employee while under service of a temporary employer. Ignorance is, or negligent acts are not a defense. So it's said that the healthcare professional really should know right and wrong under law. And most of these things will always be at least mentioned or gone over in an employee manual or handbook. There's always people to ask too. And you go with your gut. Generally, you're going to be led the right way. Now, there is a statute of limitations or a set period of time that the injured party can file a lawsuit. The only exception here is the rule of discovery, which says that the lawyers have time to begin compiling their case with their witnesses and their experts, and the case does not actually begin, the time clock does not begin until the discovery is complete. And it will never be, there will never be a statute of limitations if there is fraud involved. Res judicata means the thing has been decided, which means that it's like double jeopardy. Once the court decides the case, the plaintiff cannot decide later on to bring a new lawsuit on the same subject. Oh, I forgot about this, and I'm going to go back and sue them again. Doesn't happen. Professional liability can happen any number of ways. Physicians can be sued for pretty much anything. The institution where the physician's working or the patient is can also be sued if some of the regulatory standards have been violated. And there's also the illegal sale of drugs. Some of the last and maybe least known ones are the promise to cure. That hasn't been done since, I don't know, maybe the days when they would go out and sell snake oil. But the promise to cure, pretty much no one can take that or say that and be 100% positive that they're going to be able to be successful. So that's a contract under law, and if the person is not cured, that is a lawsuit waiting to happen. There is the law of agency, where the relationship is formed when one person agrees to perform work for another, and then you ask, well, okay, if something happens, who's liable? The employer may not have done anything wrong, but they still may be liable for someone who was working underneath them and performs an illegal act. Liability insurance is another no-brainer. Actually, anyone who works in the medical profession should have it, and it is really affordable, pennies on the dollar. It's just a very smart and intelligent way to go. It covers any damages the physician or employer must pay if he or she is sued for malpractice and loses. And it does depend entirely, really, on the nature of the specialty that the physician practices in. I mean, OB/GYN is very high, neurosurgery is very high, anesthesia now is extremely high. All licensed and certified medical professionals should carry this malpractice insurance. And again, it is not expensive at all. Generally, if you are certified by, if you're a CMA or a double AMA, if you're a medical lab professional, the organization that will give you certification generally will also offer some inexpensive type of insurance for the medical professional, but for the physician or employer, it is expensive for them. That is the difference. Now, there are other ways other than court to have a dispute solved. That can be arbitration, mediation, or a combination of the two. And it is not without cost, but it's certainly a lot less expensive than going to a lawyer and having to pay court costs, et cetera, et cetera. Arbitration is totally settled without a judge. That decision is binding. Mediation is when a third party comes in. It's not binding, and it may go forward from there if one or party or the other is not pleased. And a med-arb is a combination of the two, and it will be binding. Liability of other health professionals, there's a list here. All people here, including medical assistant or pharmacist or pharmacy assistant, etc., will be liable in certain situations and should have that insurance. Malpractice prevention, well, how do we prevent it? Safety, of course. First, general guidelines must always be followed. Communication between staff, and document, document, document. Never should anything be written in a patient's record or typed into a patient's record that has not been dated, timed, documented, and initialed by the person who is performing the service. And that, ladies and gentlemen, is the end of Chapter 6, first time PowerPoint lecture followed by or accompanied by voice. I hope this has helped, and I would love it if you could get back to me with some feedback. Take care and have an excellent day.